Good afternoon. Myself, Chodak Parsi, Assistant Professor of Commerce, GFTC, Kottagiri. Today, I discuss remedies for breach of contract under Unit 3rd. Here, remedies for breach of contract. Before going to remedies for breach of contract, what is breach of contract? Breach of contract is nothing but when one of the contracting party or any of the contracting party not perform his obligation within the stipulated period or refuse to perform his obligation, his duty within a stipulated period or reasonable time. At that time, the contract is what is called processed as the breach of contract. Means when any one of the contracting party refused to perform his respective obligation or promise, that process is called a breach of contract. Therefore, breach of contract is nothing but one of the contracting party refused to perform his obligation or fails to perform his obligation. That is called breach of contract. That is called breach of contract. Therefore, when one of the contracting party refused to perform his obligation or failure to perform his obligation, the another contracting party is entitled some remedies like what you call damages or compensation or what you call losses. That remedies is also called reliefs or benefits. Therefore, when at the time of any one of the contracting party refused to perform his obligation or what you call when one of the contracting party what you call failure to perform his promise, at that time the affected party or aggrieved party can claim damages or losses. That is called remedies for breach of contract or reliefs for breach of contract. This is what remedies for breach of contract. Therefore, dear students, so breach of contract we discuss ಮಾಡಿವಿ, remedies for breach of contract discuss ಮಾಡಿವಿ. Therefore, any one of the contracting party refuses or fails to perform his obligation, the another affected party ಅಥವಾ aggrieved party can claim damages or compensation against the what you called who fails to perform. That is called remedies or reliefs for breach of contract. Therefore, what are the remedies or what are the reliefs are available? Very important reliefs are available to aggrieved party or affected party. One is rescission of the contract, means sue for rescission. Damages for the loss suffered, means sue for damages is one side. Suit for specific performance and suit for quantum merit, suit for injunction and suit for restitution. These are the 6 remedies or reliefs are available to aggrieved party when any one of the contracting party breach the contract. Therefore, first one, sue for rescission or rescission of contract. Rescission of contract means very simple, rescind the contract, means cancel the contract, means when any one of the contracting party failed to perform his obligation or refused to perform his obligation, the another contracting party simply cancel the contract or avoid the contract. That is what called a rescission of the contract. Therefore, here in this situation, any one of the contracting party failure to perform his obligation, the second party, means affected party or aggrieved party, can claim the rescission in front of the court. The court may award rescission only 2 situations: when the contract is voidable and when the contract is what is called unlawful. Therefore, rescission of the contract means or rescission means when any of the contracting party can fail to perform his obligation. At that time, the aggrieved party or affected party can cancel his part of obligation or avoid his part of work. that is called rescission of the contract. Therefore, that is very important, simple meaning. Therefore, when one of the party of the contract breaches the contract, at that time the second party, means other party, need not perform his obligation within the due date. That is called rescission or cancel or avoid the contract or rescind the contract. Therefore, aggrieved party or affected party may rescind the contract. In such cases, aggrieved party can either rescind the contract or file the suit for against the damages. Very important. Aggrieved party, when aggrieved party rescind the contract ಅನ್ನು cancel ಮಾಡ್ತಾನೆ, at that under situation, the injured party, means aggrieved party or affected party, can either rescind the contract and also or file a suit for damages. ಇಲ್ಲಿ very important, ಅವನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದು, ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ರಿಸ್ಕೈಂಡ್ ಮಾಡಬಹುದು, ಅವಾಯ್ಡ್ ಮಾಡಬಹುದು, ಅಥವಾ ಅದರ ಜೊತೆಗೆ ಈ ಕ್ಯಾನ್ ಫೈಲ್ ಎ ಸೂಟ್ ಫಾರ್ ಡ್ಯಾಮೇಜ್, ಸೂಟ್ ಅನ್ನು ಮಾಡಬಹುದು, ಡ್ಯಾಮೇಜ್ ಕ್ಲೇಮ್. Therefore, under section 64 of the contract provides that the party who rescinds the voidable contract shall, if he has received any benefit therefrom, the other party restore such benefit to the person from whom it was received. Means, if suppose that contract is voidable or unlawful, that should be what is called breach of contract. Automatically, if any affected party can rescind the contract, at that time if any benefit is received, that should be restored to the party. ಅದನ್ನ restore ಮಾಡಬೇಕಾಗುತ್ತೆ. Therefore, the court may grant rescission in two cases. ನಾನು ಹೇಳಿದೆ ಕೋರ್ಟ್ ಎಲ್ಲ ಸಂದರ್ಭಗಳಲ್ಲೂ ಸಹ ಗ್ರಾಂಟ್ ಮಾಡೋದಿಲ್ಲ, ಈ ಎರಡು ಸಂದರ್ಭಗಳಲ್ಲಿ ಮಾತ್ರ ಗ್ರಾಂಟ್ ಮಾಡುತ್ತೆ. ಯಾವ ನಿಮಗೆ ಟೂ ಮಾರ್ಕ್ಸ್ ಅಂಡರ್ ವಾಟ್ ಸಿಚುಯೇಷನ್ ಅಥವಾ ಅಂಡರ್ ವಾಟ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ದ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ ರೆಸಿಷನ್, ಎರಡು ಕೇಸನ್ನು ಮೆನ್ಷನ್ ಮಾಡಿ ಅಷ್ಟೇ. ಒಂದು, ವೇರ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಈಸ್ ವಾಯ್ಡಬಲ್, ಇಷ್ಟೇ ಬರೀ ಸಾಕು. ವೆನ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಈಸ್ ವಾಯ್ಡಬಲ್ ಅಟ್ ದ ಆಪ್ಷನ್ ಆಫ್ ಪ್ಲಾಂಟಿಫ್ ಮೀನ್ಸ್ ಹೂ ಈಸ್ ಡ್ಯಾಮೇಜ್ಡ್ ಪರ್ಸನ್. And another one, where the contract is unlawful, means illegal, the object of the or consideration of the contract is illegal. That is, agagi the court grant rescission in the following two cases or two situations. One is where the contract is voidable, where the contract is unlawful. Then sometimes the court does not grant or refuses to grant what is called rescission. Under what situations? ಅದಕ್ಕೂ ಸಹ ಹೇಳಿದ್ದೀನಿ. There are four situations, or there are four cases are there where the plaintiff has expressly or impliedly ratified the contract. ಅಂದ್ರೆ ratify ಮಾಡಿದ್ರೆ, ರಿಟರ್ನ್ ಮಾಡಿದ್ರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ಅಪೋಸ್ ಮಾಡಿದ್ರೆ ಆಗ ಕೋರ್ಟ್ ಕೊಡೋದಕ್ಕೆ ಒಪ್ಪೋದಿಲ್ಲ. ಎರಡನೇದು, where owing to exchange the circumstances of the parties cannot restore the original positions. Means if the change the circumstances of the parties circumstances change ಆಗಿದ್ರೆ cannot be restored their original position restore ಮಾಡಕ್ಕಾಗಲ್ಲ. ಈ ಸಿಚುಯೇಷನ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ ಮಾಡೋದಿಲ್ಲ. Where the third party during the substance of the contract acquired rights in good faith for value, means for consideration, at the time the court does not grant rescission. And fourth one, where only a part of the contract is sought to be rescinded, means contractually only part of the contract is rescinded and other part is severable from the rest of the contract, at that time court does not grant rescission. Therefore, in these four cases the court does not grant rescission. Therefore, dear students, now ಇಲ್ಲಿವರೆಗೂ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದು ಕೇವಲ ಫಸ್ಟ್ ಒನ್, ದಟ್ ಇಸ್ ಸೂಟ್ ಫಾರ್ ರೆಸಿಷನ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ದ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ ರೆಸಿಷನ್ ಅಂತ ನಾವು ಹೇಳಿವಿ. ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಮೀನಿಂಗು, ಅದರ ಒಂದು ಯಾವಾಗ ಗ್ರಾಂಟ್ ಮಾಡ್ತೇವೆ ಯಾವಾಗ ಗ್ರಾಂಟ್ ಮಾಡೋ ಅಂತ ನೋಡಿವಿ. ನೆಕ್ಸ್ಟ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಸೆಕೆಂಡ್ ಒನ್, ರಿಮೆಡಿಂಗ್ ಡ್ಯಾಮೇಜಸ್ ಫಾರ್ ದ ಲಾಸ್ ಸಫರ್ಡ್ ಆರ್ sue for damages for the loss suffered or sue for damages. What is damages? Damages is nothing but it is the ordinary monetary compensation. Damages is the monetary compensation payable by the defaulting party to the aggrieved party or affected party for loss suffered by him when contract was breached. This is the meaning of damages. What is damages? That is damages for the loss suffered ಸಂಬಂಧಪಟ್ಟಂತೆ ಅಥವಾ sue for damage ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾವು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿದ್ದೀವಿ. Damages is nothing but damages means it is a what is called a monetary compensation payable by the defaulting party
to the aggrieved party for the loss suffered by him when contract was breached. When contract was breached, there is the meaning of damages. Therefore, aggrieved party or affected party can claim damages or bring an action for damages against the defaulting party or guilty at the time of breach of contract. Therefore, ಈ ಏನು ಅಫೆಕ್ಟೆಡ್ ಪಾರ್ಟಿ ಇದ್ದಾನೆ, ಅಗ್ರೀಡ್ ಪಾರ್ಟಿ ಇದ್ದಾನೆ, ಅವನು ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಾವೆನ ಹೊಡಬಹುದು. ಏನು ನನಗೆ ಈ ತರ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ, ಲಾಸ್ ಆಗಿದೆ, ಕಟ್ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವನು ಸ್ಯೂ ಮಾಡಬಹುದು, ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಅನ್ನು ಮಾಡಬಹುದು. ಯಾರ ವಿರುದ್ಧವಾಗಿ? ಗಿಲ್ಟಿ ವಿರುದ್ಧವಾಗಿ, ಯಾರು ತಪ್ಪಿಸಿದ್ದೇನೆ ಅವನ ವಿರುದ್ಧವಾಗಿ ಅಥವಾ ಡಿಫಾಲ್ಟಿಂಗ್ ಪಾರ್ಟಿ ವಿರುದ್ಧವಾಗಿ. Therefore, damages or it is a compensation or monetary compensation payable by the defaulting party to the affected party for loss suffered by him when contract was breached. This is the meaning of damages. Then ಇದಕ್ಕೆ ಸಂಬಂಧ ನಾವು ಆಲ್ರೆಡಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ. The main purpose of awarding the damages is to put the injured person in good position. ಯಾಕಪ್ಪ ಡ್ಯಾಮೇಜ್ ಕೊಡಬೇಕು ಅಂದ್ರೆ, what is the main purpose ಅಂದ್ರೆ, to award damages to the aggrieved party, to put the aggrieved party or injured person in a good position. ಒಂದು good position ಇಡೋದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ, ಏನು ಅಲ್ಲ. He would have been if performance had been rendered as promised. Therefore, the aggrieved party can recover actual damages and nothing more. Very important. Affected party means aggrieved party only recover the actual damages. Actual damages ಮಾತ್ರ recover ಮಾಡ್ಕೋಬಹುದು, ಅದಕ್ಕೆ ಹೆಚ್ಚಿಗೆ recover ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ. This is what is called damages ಸಂಬಂಧಪಟ್ಟ ಪಾಯಿಂಟ್. ಮೀನಿಂಗ್ ನೋಡಿ, what are the types of damages? Very important. Yes, ನಾವು damages meaning ನೋಡಿದ್ವಿ. ಅದರಲ್ಲಿ types of damages 50 marks important. Explain the different types of damages. 5 marks ಕೇಳಬಹುದು, 50 marks ಕೇಳಬಹುದು ಒಂದು. ಅಥವಾ what are the law ಅಥವಾ rules related to damages ಅಂತ ಕೇಳಬಹುದು, 50 marks ಎರಡು ಒಂದೇ. Damages in legal terms called compensation. Already the damages is called as monetary compensation whenever one party of the contract comes across the breach of contract, the other party right to sue for damages. ಅಂದ್ರೆ ಒಬ್ಬ ಪಾರ್ಟಿ, ಕಾಂಟ್ರಾಕ್ಟ್ ಒಬ್ಬ ಪಾರ್ಟಿ ಯಾರೇ ಇರಬಹುದು, ಅವನು ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ಬ್ರೇಕ್ ಮಾಡಿದ್ರೆ, ವೈಲೇಟ್ ಮಾಡಿದ್ರೆ ಅಥವಾ ಬ್ರೀಚ್ ಮಾಡಿದ್ರೆ, ದ ಅದರ್ ಅಫೆಕ್ಟಿಂಗ್ ಪಾರ್ಟಿ ಕ್ಯಾನ್ ಸ್ಯೂ ಫಾರ್ ಡ್ಯಾಮೇಜಸ್. ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಾವೆನ ಹೂಡಬಹುದು. Therefore, there are 4 types of damages. ಅವನ್ನ ನಾವು ಇಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, which can be claimed by the aggrieved party or affected party. So, what are the types of damages? Are rules ಅಥವಾ law related to damages. It's one and same. ಎರಡು ಒಂದೇನೆ. ಯಾವ ರೀತಿ ಬೇಕಾದ್ರೂ ಕೇಳಬಹುದು. 50 marks important, 5 marks important ಇದೆ. First, ಹಾಗಾದ್ರೆ rules or law related to damages, the types of damages ಅನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡೋದ್ರಲ್ಲಿ ಒಂದು, damages arising naturally. Damages arising naturally means it is one of the rule or law related to damages. ಅಥವಾ types ಅಂತ ಬಂದಾಗ general damages ಅಥವಾ ordinary damages. Therefore, general damages are the damages. They are arise in the ordinary course of event from the breach of contract are called general damages ಅಥವಾ ordinary damages. ಅಂದ್ರೆ general damages ಅಂದ್ರೆ it is one type of damages that arise in the ordinary course of event. In the ordinary course of event ಅಂದ್ರೆ in the ordinary situation, in the ordinary condition, in the ordinary case from the breach of contract, they are called ordinary damages. Therefore, ordinary damages is also called general damages. They nothing but the damages arise in ordinary course of event. The damages arise in ordinary course of event from the breach of contract is called general damages. General damages cover the loss directly and necessarily incurred by the breach of contract. General damages ಯಾವುದು ಕವರ್ಡ್ ಆಗುತ್ತೆ ಅಂದ್ರೆ, what are the loss or damages directly and necessarily incurred by the breach of contract. ಅಂದ್ರೆ ಯಾವುದು ಡೈರೆಕ್ಟ್ ಆಗಿ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ, ಯಾವುದು ನೆಸೆಸರಿ ಆಗಿದೆ ಅಷ್ಟು ಮಾತ್ರ ಕವರ್ ಮಾಡುತ್ತೆ. General damages are most common type of damages awarded at the type of breach of contract. It is very important. This type of damages like general damages or ordinary damages is the most type of good damages. It is awarded by the court when at the time of breach of contract to the business people or non-business people also. Therefore, damages are the one type. First type is general damages ಅಥವಾ damages arise naturally ಅಥವಾ what we call ordinary damages are the damages arise in the ordinary course of event from the breach of contract. ಅಷ್ಟೇ ಮೀನಿಂಗ್ ಜನರಲ್ ಡ್ಯಾಮೇಜ್ಗೆ. ದಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಇದನ್ನು ನಾನು ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ. ಎ ಕಂಪನಿ ಡೆಲಿವರ್ಡ್ ದ ರಾಂಗ್ ಕೈಂಡ್ ಆಫ್ ಫರ್ನಿಚರ್ ಟು ಬಿ After discovering the mistake later in the day, company B instead that company A to pick up the wrong furniture and deliver the right furniture. Company A refused to pick up the furniture and said that it could not supply the right furniture before because it was not in stock. Company B successfully sued the breach of contract. ಇಲ್ಲಿ A and B ಕಂಪನಿ ಇದೆ. A ಏನು ಮಾಡಿದೆ, ಫರ್ನಿಚರ್ ಡೆಲಿವರ್ ಮಾಡಿದೆ ಬಿಗೆ, ಬಟ್ ಬಿ ಡಿಸ್ಕವರ್ ಮಾಡಿದಾಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಬ್ರೇಕ್ ಆಗಿದೆ, ರಾಂಗ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾನೆ. ಇವನು ಏನು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಅವ್ನು ಕಳಿಸ್ಕೊಟ್ಟಿರೋದು. ಹಾಗಾಗಿ ಏನ್ ಮಾಡಿದಾನೆ, ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಬಿಗೆ, ನೋಡಪ್ಪ ಇದನ್ನ ತೆಗೆದುಕೊಂಡು ಹೋಗ್ಬಿಡು, ರೈಟ್ ಫರ್ನಿಚರ್ ಡೆಲಿವರ್ ಮಾಡು ಅಂತ. ಆದ್ರೆ ಬಿ ಒಪ್ಕೊಳ್ತಾ ಇಲ್ಲ. ಬಿ ಇಸ್ ನಾಟ್ ಡೆಲಿವರ್ಡ್ ದ ರೈಟ್ ಫರ್ನಿಚರ್ ಅಂಡ್ ಆಲ್ಸೋ ಇಟ್ ವಾಸ್ ನಾಟ್ ಇನ್ ಸ್ಟಾಕ್ ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ಫೋರ್ ಹಾಗಾಗಿ ಈ ಕ್ಯಾನ್ ಸಕ್ಸಸ್ಫುಲಿ ಸೂಡ್ ದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಾವೆನ ಹೂಡಬಹುದು. ಯಾವುದಕ್ಕೆ ದಾವೆ ಹೂಡಬಹುದು ಅಂದ್ರೆ ರೀಫಂಡ್ ಆಫ್ ಅಮೌಂಟ್ ರೀಫಂಡ್ಗೆ ದಾವೆ ಹೂಡಬಹುದು ಅಂಡ್ ರಿಯಂಬರ್ಸ್ಮೆಂಟ್ಗೆ ಹೂಡಬಹುದು. ಮೀನ್ಸ್ ಎನಿ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಸಂಬಂಧಪಟ್ಟ ರಿಯಂಬರ್ಸ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬಹುದು. ಅಂಡ್ ಪೇಮೆಂಟ್ ಆಫ್ ಎನಿ ಇನ್ಕ್ರೀಸ್ ಇನ್ ಕಾಸ್ಟ್ ಆಫ್ ಕಂಪನಿ, ಯಾವುದೇ ಕಾಸ್ಟ್ ಇನ್ಕ್ರೀಸ್ ಆಗಿದ್ರೆ ಅದನ್ನ ರಿಮರ್ಸ್ ಮಾಡ್ಕೋಬಹುದು. ದಟ್ ಇಸ್ ಅ ಟೈಪ್ ಆಫ್ ಜನರಲ್ ಡ್ಯಾಮೇಜಸ್. ಇಟ್ ಇಸ್ ಎಕ್ಸಾಂಪಲ್ ಜಸ್ಟ್ ಅಷ್ಟೇ. Therefore, in this session, I discuss only first breach, that is like first remedy for breach ಯಾವುದು, sue for rescission and discuss ಮಾಡಿವಿ. and ಎರಡನೇದು second one sue for damages, that is ಅದರಲ್ಲಿ ಟೈಪ್ಸ್ ಆಫ್ ಡ್ಯಾಮೇಜ್ ಅನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿದ್ದೀವಿ. ದಟ್ ಇಸ್ ಫಸ್ಟ್ ಒನ್ ಜನರಲ್ ಡ್ಯಾಮೇಜ್ ಅನ್ನು ಅಥವಾ ಆರ್ಡಿನರಿ ಡ್ಯಾಮೇಜ್ ಅನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡಿವಿ. ಇನ್ ನೆಕ್ಸ್ಟ್ ಸೆಷನ್ ಐ ಡಿಸ್ಕಸ್ another type of damages. Okay, thank you.